Thank you everyone for joining us today. My name is Zach Cahan, and I'm a special assistant in the Department of Health and Human Services, Office of Intergovernmental and External Affairs. Yesterday, we finalized modifications to the confidentiality of substance use disorder patient records regulations at 42 CFR Part 2, which protect the privacy of patients' treatment records. During today's webinar, we will be hearing from HHS's Director for the Office for Civil Rights, Melanie Fontes Rainier, Assistant Secretary for Mental Health and Substance Use, and leader of SAMHSA, Dr. Miriam Delphin-Rittman, Dr. Jim Gandotra, Chief Medical Officer at SAMHSA, and Tim Noonan, Deputy Director for Health, Information, Privacy, Data, and Cybersecurity at the Office for Civil Rights. There's a lot to cover here, so I'll quickly outline the rules of the road. First, this meeting is closed press. If you are a member of the press, we ask that you please leave the call now. If you have any logistical questions during the webinar, please feel free to place them in the Q&A. To start us off, I will turn it to Director Fontes Rainier of the Office for Civil Rights.
Thanks, Zach. Good afternoon, everyone. Really wonderful to be here with all of you. I am Melanie Fontes Rainier. My pronouns are she, her, ella. I'm the Director of the Office for Civil Rights at the U.S. Department of Health and Human Services. I am a Mexican-American woman with light skin, dark black curly hair, and I'm wearing a light brown turtleneck dress today. Really wonderful to be able to do this event today with SAMHSA, and a big thanks to Assistant Secretary Delphine-Rittman for joining me here today and for all of the work of her team in supporting this final rule. We're so excited to have you here to help us celebrate what is a huge accomplishment for the Biden-Harris administration, HHS, and most importantly, for Americans living with and in recovery from substance use disorders. Thanks to the help of our team at OCR and the team at SAMHSA, we've published a final rule yesterday that modifies Part 2 of the confidentiality of substance use disorder patient records regulations, which protect records of the identity, diagnosis, prognosis, and treatment of patients receiving care for substance use disorders. My office, the Office for Civil Rights, took on this pursuit as a directive of Congress, where the CARES Act received bipartisan support for improving privacy measures for patients with substance use disorders within the Part 2 program. The bill passed because in every corner of this country, Americans with substance use disorders and their families have been discriminated against because of their disability. And in our work at the U.S. Department of Health and Human Services, we are all working to see how a different piece of this discrimination impacts the provision of health and human services. My office is a sole office tasked with the intersection of non-discrimination in healthcare and patient privacy, which has given us unique insight into how discrimination has made it difficult for people who are struggling with highly stigmatized disease receive adequate care. In our work in this space, we've heard from a number of patients who have been discriminated against on the basis of their substance use history and child welfare programs, patients who have had their health information misused in criminal investigations, and patients who have struggled to enter and stay in quality treatment centers due to confusing consent processes or denials of placement in the first instance because they are in active treatment and recovery. Today, we offer a path forward for these patients and anyone who struggles with substance use disorders to help ensure patient privacy and allow for strengthened care coordination. Our final rule today simplifies the consent process. Patients can now sign a single consent for all future uses and disclosure for treatment, payment, and healthcare operations instead of multiple times for the use or sharing of their medical records. This rule applies to programs related to the substance use disorder programs under Part 2, HIPAA-covered entities and business associates, allowing them to share records while adhering to the HIPAA rules. This rule also prohibits the discriminatory use of consent healthcare records for purposes other than original intent in criminal, administrative, or legislative proceedings, ensuring transparency and preventing unnecessary disclosures of substance use disorder with respect to patient information, helping to reduce stigma and encouraging care. And it strengthens privacy protections by aligning Part 2 with the HIPAA privacy rule and provides for a specific clarification which solidifies protections that prohibit the use of medical records against individuals in legal, administrative, or legal proceedings without their consent or court permission is prohibited. Part 2 penalties will be aligned with HIPAA, and instead of criminal penalties, both civil and criminal enforcement authorities under HIPAA will be utilized. This change is expected to give patients more confidence that their information is secure when they seek medical care. Our final rule establishes a standard for notifying patients about health information breaches under Part 2, again, ensuring consistency and compliance with the HIPAA breach notification rule. And the change will allow individuals with substance use disorders that they become informed if their private health information is shared without consent. It provides patient notice. We're enhancing the patient privacy rights by aligning the requirements of Part 2 patient notice with those of the HIPAA Notice of Privacy Practices to ensure both consistency amongst both programs and clarity in how communication happens when protected health information is involved and how it should be handled during treatment. To determine, again, we created a safe harbor eligibility here. A protective framework has been created for investigative agencies by aligning steps to verify healthcare provider eligibility under certain rules, such as checking SAMHSA's online locator and reviewing the HIPAA privacy practices notices. The changes are the result of a lot of hard work, meetings with advocates, and careful consideration for the most pressing issues to align these two rules. And I want to take a moment to thank our teams. From my team, I want to thank Tim Noonan and his staff, and I over at SAMHSA, of course, our Assistant Secretary, Dr. Miriam Delphine Rittman, as well as her team of Tom and Dr. Gandotra and others. We really appreciate all that you did. So with that, I am pleased to pass this over to my friend and colleague, Dr. Delphine Rittman. Thank you.
Good afternoon, and thank you so much, Director Rayner. It is such a pleasure to be here. I am Dr. Miriam Delphine Rittman. I'm the Assistant Secretary for Mental Health and Substance Use and Administrator SAMHSA. My pronouns are she, her, and I am an African-American woman. I'm wearing a maroonish jacket, and I have black hair. But again, I just want to say a special thank you to Director Rayner for your leadership at the Office of Civil Rights and the staff from both divisions that have been working tirelessly to finalize this important healthcare regulation. The Office of Civil Rights has been and continues to be such a wonderful partner throughout the process and is committed to ensuring the privacy protections for all patients. This new rule was authorized through the Coronavirus Relief and Economic Security Act and reflects comments from stakeholders and consultation with tribal organizations. We thank everybody for their interest in this topic, and we thank all those who put forward comments and recommendations as well. According to SAMHSA's National Survey on Drug Use and Health, we know that most people who misuse substances are not in treatment. This represents a major area of focus for improvement as this regulation goes into effect. While the reasons for individuals who use drugs while the reasons for avoiding treatment, they really vary widely. It is understood that fear of stigma related to their substance use disorder diagnosis may be a major factor. 42 CFR Part 2 regulations were initially promulgated to address the fear of unauthorized disclosure of their substance use records. Many providers, healthcare systems, laboratories, and other stakeholders have struggled with coordinating care for patients with substance use disorder due to both perceived barriers and fear of noncompliance. HHS believes that a holistic approach to treatment that addresses all of a patient's needs is so critical. People who misuse drugs and often have other health conditions that need to be addressed. To do this, care must be coordinated among various primary and specialty providers, healthcare systems, testing facilities, and others. We at SAMHSA and the Office of Civil Rights believe that the new changes to 42 CFR Part 2 will help with care coordination and reduce the respective fears among patients with SUD, as well as their respective healthcare providers. Namely, the closer alignment of 42 CFR Part 2 with the more widely known HIPAA regulation will help to demystify the regulation for providers, healthcare systems, and others who handle patient records. Secondly, the requirements for disclosure and penalties for unauthorized disclosure and breach notification should reassure patients that their substance use disorder diagnosis is less likely to be inappropriately disclosed, thereby removing another barrier to treatment entry and care coordination. While there's more to be done, we know there's so much more to be done here. These regulations will enhance patients' protections while facilitating appropriate sharing of records to deliver better care coordination. We look forward to continued efforts in these areas, potentially expanding access and improving care. So again, thank you so much for your interest in this work and for being with us today for this call. It is now my pleasure to turn the floor over to Dr. Jim Gantotra, who is SAMHSA's Chief Medical Officer, to further discuss the 42 CFR Part 2 background regulation. Thank you.
Good afternoon. Thank you, Assistant Secretary Delphin Rittman and Director Rayner. I want to also thank you all for your attendance and interest. My name is Jim Gantotra, the Chief Medical Officer here at SAMHSA. My pronouns are he, him, and his. I'm an Indian American man with black hair wearing a white shirt, striped tie, and dark gray jacket. I will now discuss the background of this regulation. Title 42 of the Code of Federal Regulations, CFR Part 2, Confidentiality of Substance Use Patient Records, was first promulgated in 1975, originally to address concerns about the potential use of substance use disorder in non-information treatment-based settings, such as administrative or criminal hearings related to the patient. And also, the purpose of this confidentiality law was to ensure that the person with a substance use disorder was not made more vulnerable to discriminatory practices and legal consequences as a result of seeking treatment. Patients with substance use disorder have faced enormous consequences that have been associated with disclosure. These have included loss of employment, loss of housing, loss of child custody, loss of benefits, even discrimination by medical professionals. Of course, the fear of arrest, prosecution, and incarceration exists when they're seeking treatment as well. Consequently, many persons with substance use disorder have reflected personally that they fear seeking treatment as they believe that knowledge of their substance use will become a further vulnerability to their lives and to the lives of their families. As such, 42 CFR Part 2 really does recognize that without strong guarantees of confidentiality, people in need of substance use disorder treatment will be reluctant to seek care. Not only will they be reluctant to seek services due to the concerns of collateral consequences that result from their substance use, they also are concerned about arrest and prosecution, the loss of custody or parental rights, eviction from public housing. Additionally, protecting confidentiality is important to protect the individual against the stigmatization of their disorder. We know that many individuals with substance use disorder feel stigmatized themselves, and when they experience it in the community and at the provider setting, it really does dehumanize their condition. Ultimately, though, confidentiality protections hopefully help address some of the concerns that discrimination and fear of prosecution that usually deter people from entering treatment for substance use disorder. Next slide, please. So, in general, programs that fall under 42 CFR Part 2 are prohibited from disclosing any information that would identify a person as having a substance use disorder or having had a substance use disorder unless that person provides written consent. 42 CFR Part 2 specifies a set of requirements for these consent forms as well, but these include but are not limited to the name of the patient, the name of the individuals or entities that are permitted to receive or disclose that patient identifying information, the amount of and the kind of information to be disclosed, and of course, the purpose of disclosure. To further specify, patient identifying information means the name, the address, social security number, fingerprints, photographs, or other similar information by which the identity of the patient can be determined with reasonable accuracy and speed, either directly or by reference to any other publicly available information. Now, this also includes verbal statements. So, of course, written or unrecorded patient information may not be disclosed. So what kind of organizations are really subject to this Part 2 regulation? In general, Part 2 applies to any federally assisted program that provides substance use or alcohol treatment, diagnosis, or referrals to treatment. It applies to both organizations whose sole purpose is to diagnose and treat substance use disorder, as well as units within larger organizations such as clinics within a jail, prison, or hospital. There's also a low bar to be considered as federally assisted. Most drug and alcohol programs are federally assisted, which means that the program derives some type of benefit from the U.S. government. This includes treatment providers that rely on federal grant funds, organizations that accept Medicaid, private clinics that are licensed by the DEA to provide medications or medication-assisted treatment, and those receiving nonprofit status under the federal tax code. In general, while 42 CFR Part 2 requires individual consent before identifiable information about substance use disorder treatment can be shared, there also exists substantive and procedural requirements for obtaining and documenting an individual's consent to disclose substance use information. As previously mentioned, consent must contain a set of elements, such as the name of the parties involved in the disclosure, the reason for the disclosure, the type of information requested, but also preclusions against redisclosure and duration of consent. Recognizing that there may be circumstances that consent might not be possible in specific situations, some of these situations where consent have been outlined and where consent might not be required. Medical emergencies, of course, are one exception. Part 2 permits patient identifying information from a protected source to be disclosed to medical staff for the purpose of treating a physical or mental health condition that poses an immediate threat to the individual's health. Additionally, there are other circumstances that may have exceptions to the consent requirement, which permit programs to disclose or use substance use patient information. In the course of internal program communications, in a communication with a qualified service organization, these would be an outside organization that provides services to the program, such as dosage preparation or laboratory functions. In response to a crime against the program personnel or on the program premises, this may also include threats to commit such a crime. For research activities, for audit and evaluation activities, to report suspected child abuse or neglect, in circumstances involving certain minors or incompetent patients who may not have capacity for informed consent, in response to a valid court order. It's important to note here that 42 CFR Part 2 requires a special court order that depends on the satisfaction of higher standards before disclosure can be made to law enforcement. And it's also important to note that all of these exceptions, while in place, have very specific requirements and are limited in scope. Part 2 consent requirements apply to care providers when disclosures are for the purposes of coordinating an individual's treatment for other health conditions. As another point to consider, Part 2 still applies to all Part 2 records after the records leave the hands of the Part 2 program. In essence, these regulations follow the information. As such, Part 2 regulations have been reported as a barrier by some stakeholders to legitimate health record sharing among providers who legitimately seek to coordinate care and services, as many other healthcare settings provide services outside of Part 2 programs, and they follow other privacy laws such as the Health Insurance Portability and Accountability Act, HIPAA as it's known. And HIPAA generally permits the disclosure of protected health information for certain purposes without patient authorization. These include treatment, payment, or other healthcare operations. The CARES Act legislation seeks to align Part 2 with HIPAA to increase the potential for care coordination between providers and to allow for a more holistic treatment plan to be developed and implemented. I will now turn over to Deputy Director Tim Noonan from the Office of Civil Rights, who will continue the briefing with regard to the specific CARES Act provisions.
Thank you, Dr. Gandotra, Director Fontes Rayner, and Assistant Secretary Delphin Rittman. Hello, everyone. I am Timothy Noonan. As Dr. Gandotra said, I am the Deputy Director for Health Information, Privacy, Data, and Cybersecurity at the HHS Office for Civil Rights. My pronouns are he, him, and his, and I'm light-skinned. And today I'm wearing a black jacket, a blue shirt, red tie, and glasses. It is my pleasure to be speaking with you today about the final rule implementing changes required by the CARES Act to the confidentiality provisions of the Part 2 regulations. In late 2022, OCR and SAMHSA published a notice of proposed rulemaking to modify the Part 2 rules to implement the CARES Act requirements to better harmonize the Part 2 confidentiality requirements with certain permissions and requirements of the HIPAA rules and the HITECH Act. Following a 60-day public comment period and review and consideration of public comments received, we issued the final rule, which went on public display at the Federal Register yesterday. The final rule will become effective 60 days after the date of publication in the Federal Register, and then the compliance date by which persons subject to this regulation must comply with the requirements of the final rule will be 24 months after the date of publication in the Federal Register. Today, I'd like to highlight some of the significant changes that have been made to the Part 2 confidentiality provisions as a result of this final rule. So the first change concerns patient consent for uses and disclosures of Part 2 records. And the final rule creates a new option for patients to provide a single prior consent for all future uses and disclosures of Part 2 records for treatment, payment, and healthcare operations without the Part 2 program having to get the consent from the patient for each future use or disclosure for those purposes until the consent is revoked by the patient. So if a Part 2 program receives a signed single consent from a patient to use and disclose their Part 2 records for treatment, payment, and healthcare operations, the Part 2 program can use the patient's records for healthcare operations, such as reviewing the competence or qualifications of a healthcare professional, evaluating practitioner and provider performance, or conducting training programs. And they can do this without having to seek the patient's consent for each use and disclosure. And as I said, this continues unless or until the patient revokes the consent. This should be beneficial to Part 2 regulated entities, as it will facilitate greater efficiencies for treatment, payment, and healthcare operations, and patients still have the ability to revoke their consent. The next change is a little broader and applies to re-disclosures of Part 2 records for certain purposes beyond treatment, payment, and healthcare operations. And so this permits the redisclosure of Part 2 records in accordance with the HIPAA privacy rule by recipients that are HIPAA-covered entities, including those that are Part 2 programs. So there are some Part 2 programs that also meet the definition of a HIPAA-covered entity, so this would apply to them as well, and HIPAA business associates, except for certain legal proceedings, which I'll be discussing in a separate section. Now, a Part 2 program that is not a HIPAA-covered entity would be permitted to redisclose the Part 2 records according to the scope of the patient's consent that was provided. So a couple of examples. If a Part 2 program discloses Part 2 records to a patient's primary physician, so HIPAA-covered entity, based on the patient's consent for all future uses and disclosures for treatment, payment, and healthcare operations. If the patient's primary physician, a HIPAA-covered healthcare provider here, that physician could redisclose the Part 2 records as is permitted or required by the HIPAA privacy rule. In comparison, where a residential Part 2 program discloses Part 2 records to a private outpatient substance use disorder treatment center based on a patient's consent for all future uses and disclosures for treatment, payment, and healthcare operations. And the treatment center is not a HIPAA-covered entity because it only accepts cash payment for healthcare, therefore doesn't meet the definition of a HIPAA healthcare entity. Then that treatment center could redisclose the Part 2 records only for the purposes specified in the patient's consent. And it would need to obtain a new patient consent to use or disclose the records for a different purpose. So again, like the first change, this expanded ability to redisclose Part 2 records will facilitate greater integration of substance use disorder treatment information with the patient's protected health information. And hopefully, these changes to align more closely with the HIPAA privacy rule will make it a little easier for healthcare providers to understand the applicability of law. Since the HIPAA privacy rule has been in effect for more than 20 years, this should make it easier for them as they're already familiar with it. Next is a set of additional protections similar to what we see in HIPAA for psychotherapy notes under the HIPAA privacy rule. And these extra protections apply to the notes of a treating substance use disorder clinician documenting the conversation during a substance use disorder counseling session that are maintained separately from the medical record or Part 2 record. So substance use disorder counseling notes. And in the final rule, use and disclosure of substance use disorder counseling notes requires a separate patient consent before they may be used or disclosed, with a few limited exceptions. So an additional protection on substance use disorder counseling notes requiring a separate patient consent beyond other consents that may be given, such as for a treatment, payment, and healthcare operations. Next slide, please. The final rule also adds a new patient right to an accounting of disclosures of Part 2 records and a right to request restrictions on disclosures of Part 2 records. So starting with the accounting of disclosures requirement, the CARES Act provides that the HITECH Act's accounting of disclosure provision shall apply to Part 2 records. And what the HITECH Act provides is that where a HIPAA-covered entity uses or maintains an electronic health record with respect to protected health information, an individual shall have a right under HIPAA to receive an accounting of disclosures of protected health information made by the covered entity in the 3 years prior to the accounting of disclosure request. Individuals would now have this right for Part 2. The accounting of disclosures will apply to disclosures of Part 2 records made with patient consent and disclosed for treatment, payment, and healthcare operations made through an electronic health record and will cover a period of up to 3 prior years. The accounting of disclosures requirement for Part 2 will not become applicable until a final HIPAA rule for the accounting of disclosures is issued, because the Part 2 accounting provisions are based on the underlying HITECH accounting of disclosures requirement as they apply to HIPAA-covered entities. So I'll give you an example. When the HITECH accounting requirements are finalized, a patient will be able to request an accounting of disclosures of their Part 2 records to learn if there's been any disclosures in their past 3 years to other treating physicians. The final rule also implements 2 rights with respect to restrictions on disclosures of Part 2 records. One, a new right for patients to request restrictions on disclosures of their Part 2 records, otherwise permitted for treatment, payment, and healthcare operation purposes. And second, a patient right to obtain to obtain restrictions on disclosures to health plans for services paid in full by the patient. So, for example, under the right to request restrictions on disclosures of their Part 2 records, a patient in treatment for substance use disorder who signs a single consent for all future uses and disclosures for treatment, payment, and healthcare operations may ask their substance use disorder counselor not to disclose information about a history of childhood trauma when referring the patient for drug testing. The substance use disorder counselor would not be required to agree with the request, but if the substance use disorder counselor does agree, then they are required to withhold the information. So that's the right to request restrictions. For the patient right to obtain restrictions on certain disclosures to health plans, a Part 2 program must agree to the patient's request if the disclosure is for the purpose of carrying out payment or healthcare operations and is not otherwise required by law. And two, the record pertains solely to a healthcare item or service for which the patient or person other than the health plan on behalf of the patient has paid the Part 2 program in full. So again, give an example. A patient that is a member of their spouse's health plan and is receiving treatment in a Part 2 program can request and obtain restrictions on disclosures to their health plan of records about their substance use disorder treatment appointments when they paid for the appointments in full out of pocket. The Part 2 program would not be permitted to disclose the Part 2 records about those appointments to the patient's health plan. Patients will be notified of these rights in the patient notice or HIPAA notice of privacy practices, which we'll discuss in a little bit. Next, the final rule clarifies and expands the prohibitions on the use and disclosure of Part 2 records in criminal, civil, administrative, or legislative proceedings conducted by a federal, state, or local authority against a patient, absent a court order or the consent of the patient. So previously, Part 2 prohibited the use or disclosure of Part 2 records to criminally investigate or prosecute a patient. And the CARES Act, and now the final rule, expands this prohibition to also include the use of testimony that relays the content of such records and applies the prohibition to applications for a warrant. Absent patient consent or a court order, the final rule prohibitions on disclosures are on the introduction into evidence of a record or testimony in any criminal prosecution or civil action before a federal or state court. Number two, reliance on the record or testimony to form part of the record for decision or otherwise to be taken into account in any proceeding before a federal, state, or local agency. Three, the use of such record or testimony by any federal, state, or local agency for a law enforcement purpose or to conduct any law enforcement investigation. And four, the use of such record or testimony in any application for a warrant. So give a couple examples here. In a criminal prosecution of a patient for theft, not only the Part 2 record, but also testimony that relays information contained in a Part 2 record could not be used by law enforcement absent patient consent or court order. The second example, a patient's Part 2 records or testimony about those records could not be used by law enforcement as part of an application for a search warrant, again, absent the patient's consent or a court order. Next is really a really significant change. It creates a civil enforcement for violations of the confidentiality provisions of the Part 2 regulations. Previously, the enforcement of the confidentiality provisions of Part 2 was limited to criminal sanctions. And so this final rule implements the CARES Act requirement to apply the civil and criminal provisions of the Social Security Act to a Part 2 program for a violation of the confidentiality provisions in the same manner as they apply to a covered entity for a HIPAA violation. So now, in addition to potential criminal penalties, for the first time, a Part 2 program could be subject to a civil money penalty for violations of the Part 2 confidentiality provisions. Patients will have a right to file complaints of violations of the Part 2 confidentiality provisions with the Secretary of HHS. And this is really going to be parallel to the HIPAA privacy rule. And OCR receives many complaints from the public. There's a portal that allows for the filing of complaints. In addition to being able to file a complaint with HHS, patients will also have a right to file a complaint directly with a Part 2 program. HHS now has civil enforcement authority to investigate complaints and initiate compliance reviews of Part 2 programs concerning potential Part 2 confidentiality violations, similar to the department's civil enforcement authority for potential violations of the HIPAA rules. The HITECH Act created a tiered civil money penalty structure based upon the knowledge of the regulated entity with respect to a HIPAA violation. And presently, for willful neglect uncorrected, which is the highest tier in the HITECH Act, it provides for an approximate $2 million civil money penalty for all violations of an identical requirement in a calendar year. And so the civil money penalty structure that is used in HIPAA will now be applicable to Part 2 programs. Civil enforcement of the Part 2 regulations under the HITECH tiered civil money penalty structure should create a significant financial deterrent to violations of the Part 2 regulations that doesn't currently exist. The final rule implements a requirement for Part 2 programs to report breaches to the HHS Secretary in the same manner, really, as set forth in the HITECH Act for breaches of unsecured protected health information by HIPAA-covered entities. And so a breach is generally an impermissible use or disclosure under the privacy rule that compromises the security or privacy of protected health information. An impermissible use or disclosure of protected health information is presumed to be a breach unless the covered entity or business associate demonstrates that there's a low probability that the protected health information has been compromised based upon a risk assessment. Now, in the event of a breach of Part 2 records, Part 2 programs would be required to notify the Secretary, affected patients, and in some cases, the media. Upon discovery of a breach of unsecured Part 2 records, a Part 2 program would have no more than 60 calendar days to report the breach to the individuals affected, and if the breach affected 500 or more individuals, to HHS. Breaches affecting 500 or more, affecting less than 500 individuals can be reported to HHS annually. The breach notice requirements also follow what is in HIPAA. So there will be a brief description of what happened, such as the date of the breach and discovery, a description of the types of unsecured records that were involved, steps patients should take to protect themselves from potential harm, and a brief description of the mitigation steps taken by the Part 2 program, as well as contact information so the patient can learn more information. HHS maintains a breach portal where large breaches of unsecured protected health information affecting more than 500 individuals are submitted and posted. And a similar program will be set up for the reporting of Part 2 records. Next slide, please. The final rule permits disclosures of Part 2 records without patient consent, so no patient consent, for public health purposes, but it's limited to information that is de-identified according to the standard in the HIPAA privacy rule. So again, the final rule permits Part 2 record disclosures without patient consent for public health purposes, but the information has to be de-identified. The HIPAA privacy rule provides two methods for determining whether health information is individually identifiable. And so this is how you de-identify health information. One, known as the expert method, provides where a person with appropriate knowledge of and experience with generally accepted statistical and scientific principles and methods for rendering information not individually identifiable. This expert determines that the risk is very small, that the information could be used alone or in combination with other reasonably available information to identify an individual who is the subject of the information. The second method involves the express removal of 18 identifiers which include name, social security numbers, email addresses, telephone numbers, account numbers, full face photos, things of that nature. Health information that is de-identified is not protected health information, and the HIPAA rules do not apply to de-identified health information. Similarly, Part 2 confidentiality provisions only apply to patient identifying information. And so this provision in the final rule will allow de-identified Part 2 records to be disclosed for public health purposes without a patient's consent, but they are de-identified. So an example, Part 2 records about patients receiving treatment for a substance use disorder and who have overdosed on opioids could be reported to a public health authority that needs such information, provided that the records have individually identifiable information removed using one of the two methods I just described. Next, the final rule adds changes to the notice that Part 2 programs are required to give patients about their rights and the uses and disclosures of Part 2 records. The final rule aligns the patient notice with the required elements of the HIPAA Notice of Privacy Practices and retains the provisions that are unique to Part 2. The privacy rule requires that notice be provided to individuals about how a covered entity may use and disclose the individual's protected health information, as well as the individual's rights and the covered entity's obligations with respect to the individual's protected health information. Similarly, the final rule requires Part 2 programs to provide notice to patients regarding Part 2 records, including patients' rights and uses and disclosures permitted or required without the patient's consent. So, for example, the Part 2 patient notice has to include notice of the new rights we discussed earlier for patients, the right to receive an accounting of disclosures and a right to request restrictions on disclosures for treatment, payment, and healthcare operations. Additionally, the CARES Act requires modifications to the HIPAA Notice of Privacy Practices so that covered entities that have Part 2 records are required to include information about how they handle Part 2 records. And this requirement will be implemented in a separate final rule along with other changes to HIPAA's Notice of Privacy Practice requirements, because HIPAA only allows changes to particular requirements to be made once every 12 months. Finally, the final rule adds a safe harbor from liability for violations of the Part 2 confidentiality provisions by investigative agencies that in good faith, unknowingly, are in receipt of Part 2 records and therefore have not obtained the required court order. The final rule finalizes the proposal from the NPRM that allows investigative agencies to retroactively apply for a Part 2 court order if they can demonstrate that before requesting any records from the provider, the investigative agency first exercised reasonable diligence to determine if the entity was in fact providing substance use disorder treatment. The reasonable diligence steps include searching SAMHSA's online treatment locator, searching a similar state database where available, checking the provider's publicly available website where available, or its physical location to determine whether it provides such services, and viewing the provider's patient notice or HIPAA Notice of Privacy Practices when available online or at the physical location. The final rule added searches of the SAMHSA and state treatment facility databases to replace the proposal from the NPRM to search a prescription drug monitoring program database, because the treatment databases contain a broader range of providers and are more readily available for investigative agencies. It also added viewing the patient notice of privacy practices because they are readily available and provide information about Part 2 records. The final rule clarifies that the investigative agency must immediately cease using and disclosing Part 2 records it discovers in its possession until it takes certain steps, such as returning or destroying the records or applying for a court order. And finally, the final rule requires investigative agencies to report to the HHS Secretary within 60 days following the end of the calendar year the number of applications made for court orders that occurred after discovery that an investigative agency unknowingly received Part 2 records or placed undercover agents and informants. And these reports must include the number of instances in which such applications were denied due to findings by the court of violations of this part, and 2, the number of instances in which records under this part were returned or destroyed following unknown receipt without a court order. Next slide, please. Here are some resources. The final rule can be found on multiple websites. Right now it's on public display at the Federal Register. There's also a helpful fact sheet that's been published that provides information on the background, major changes in the new Part 2 rule, and substantive changes made from the NPRM. And then finally, SAMHSA has a Center of Excellence that develops and disseminates training, technical assistance, and educational resources for healthcare practitioners, families, individuals, states, and communities on various privacy laws and regulations as they relate to information about mental and substance use disorder. And among the items covered include HIPAA and Part 2. And so that can be a great resource for additional information, for questions, training, technical assistance, etc.